Hello, everybody. It's lovely to be here and a real pleasure to be able to introduce Colin. I'm going to start with this.
Remarks. Too often, we have seen what happens when technology outpaces regulation. The unbridled exploitation of personal data, the proliferation of disinformation, and the deepening of societal inequalities. We have seen how algorithmic biases can perpetuate discrimination and prejudice, and how the lack of transparency can undermine public trust. This is not the future we want. If you were listening from home, you might have thought that voice was mine and the words from me, but in fact, that voice was not mine. The words were not mine. And the audio was an AI voice cloning software trained on my floor speeches. The remarks were written by ChatGPT when it was asked how I would open this hearing. And you heard just now the result.
That was Senator Richard Blumenthal opening up a Senate committee yesterday, at which Sam Altman spoke. And those of you that read that news piece will know that Sam, who is the CEO of OpenAI, is calling for regulation of AI. And we're now seeing an increasing number of people that say we need to pause, we need to govern, we need to regulate. So I can't think of a more timely moment for Colin to come and talk to us about the subject of AI regulation and how we balance innovation and the speed of innovation and creation of opportunities with precaution and ensuring that we do good in the world. Colin has come to us from the University of Otago in New Zealand, which he told me is the most southern university in the world. Yeah, so there you go, where he was at. Now let me see if I can get this right. The Centre for Law and Policy of Emerging Technologies. Is that right?
That's part of the name, but yes, you're right.
And I think there's something about the New Zealand Law Foundation in there as well. Thank you. Colin's research interests sits at the sort of intersection of reproductive technologies as well as AI and regulation. And he's just co-authored a book on A Citizen's Guide to AI, which I think sounds like mandatory reading actually for a lot of people. Really looking forward to hearing your talk today, Colin, and I'll be back to host some questions for those of us that are here and in the room and online. Yeah. And for those of you that are online, I am real, and I believe Colin is also real.
Thanks very much for that introduction, Richard, and thanks as well, Healy, for the housekeeping. Remember the special code fire alarm if the questions get too tough. Okay, so I should say first of all, by way of a lawyerly caveat, that I've interpreted the introduction remit fairly literally. So don't expect anything paradigm shifting in terms of insight into the law here today. I see this really as the start of a conversation, or I guess a bunch of conversations with my new colleagues and new fellow citizens in Bristol, because there's an awful lot here that I still don't know the answer to. The title of this talk, nope, that's not it. The title of this talk, as you possibly recognise, is a remix of Mark Zuckerberg's Move Fast and Break Things, his original motto for Facebook. Something I think that was taken up by the more disruptor elements in the tech industry thereafter. I should say, in fairness to Mark Zuckerberg, they changed that motto in 2014 to, I think it was, move fast with stable infrastructure, which doesn't look quite so good in a t-shirt. But what I'm looking at today is how does law and regulation, I'm going to use these terms somewhat mischievously interchangeably, how do they keep pace with fast-moving technology? How can we move fast and mend things, or maybe move fast and prevent them from getting broken in the first place? I want to try and achieve a few things with this talk, I guess. I would like to introduce myself and the work I do. I want to talk a little bit about what tech lawyers do. Some of this will be awfully familiar to some of my tech law colleagues here, maybe a wee bit less so to others. The kind of challenges they face, the kind of strategies available to them when trying to get to grips with and stay to grips with fast-moving technologies. And I also want to flag up, though, a few areas where I've kind of hit a wall, I guess, in terms of my own research, my own disciplinary limits, and where some kind of insight from other disciplines I think would be very useful. But first, a little bit about me. I started my academic journey at this place, the University of Glasgow, where I was an undergraduate and then a postgraduate and then a lecturer there. Having spent the early years of my academic career at Glasgow, about an hour from the town where I grew up in actually, I decided it was time for a change of scene. So my partner and I decamped about 20,000 kilometres around the world to, as Richard said, the southernmost university campus in the world for a complete change of scene, and ended up in this place. It is, Dunedin's a lovely city and I totally recommend it. It's also the most Scottish place I've ever been, including Scotland. I heard more bagpipes there than I ever did here. As Richard said, it was to take up the directorship of New Zealand's first Law and Technology Research Centre. It was the gloriously monikered New Zealand Law Society, New Zealand Law Foundation Centre for Law and Policy and Emerging Technologies. It's a bit of a mouthful, but luckily we were blessed with a nice snappy acronym for that. One of the main draws, in fact, of working at the BDFI is it's got an acronym you can actually say without pausing for a rest break halfway through. And then on, obviously, to Bristol. The first part of my academic journey was actually as a medical lawyer. There's a famous saying in medical law about the relationship between law and medicine. It comes from an Australian judge, Justice Windayer, and he described law as marching with medicine, but in the rear and limping a little. Well, if that was true with regard to medicine, how much more true is it with regard to technologies like artificial intelligence? These days it sometimes feels like law isn't so much in the rear and limping, but being regularly lapped and hoping to catch on to the coattails of AI as it zips past. To be honest, well, technology academia can find a bit the same sometimes. I've been talking to some of you about that. The relationship between technology and law is often expressed something like this. These are literally the very first two images for law and technology that I got in a Google image search when I was putting this together. Law is seen as being slow to make and slow to change, reactive to events, predictable in the sense of once it's in place we should be able to predict more or less how it will apply to our actions. And of course law has to fit together, or it really ought to fit together, with other laws. Technology, in contrast, is seen as being fast-moving, innovative, unpredictable in all kinds of ways, and disruptive of existing paradigms, technological and social. The truth, though, is that technology isn't always fast-moving. Sometimes there are long lulls during which progress slows and early promise isn't fulfilled. Think of the famous AI winter. All the yet to be fulfilled promises of previous change everything technologies like nanotechnology or gene therapy. They still might change everything, but you couldn't really accuse them of getting out ahead of public and academic discourse or of the opportunity to regulate. At the same time, law isn't always slow to change. In the aftermath of the Christchurch terrorist massacre in New Zealand on the 15th of March 2019, and the online proliferation of footage taken by the shooter during that massacre, Australia fast-tracked a legislative response, the Sharing of Abhorrent Violent Material Act. And when I say they fast-tracked it, let's take a look at this timeline. So the massacre was 15th of March. By the 3rd of April, they drafted and introduced legislation. It had made its way through the whole of the legislative process and received royal assent by the 5th of April 2019. I'm fairly sure I've spent longer on hold to my bank than that. That is a remarkably fast process of law drafting and law making. Whether that's a good law or a good way to make law are valid questions, but it does show that lawmakers can respond very quickly indeed to new technologically mediated harms and risks. So why don't they do that more often? Why has it taken 2 years for the European Union's AI Act to get from first draft to the stage of actually being voted on? And about the same time for the UK's online safety bill to get only about halfway through the House of Lords part of the legislative process. Well, there's a difference, I guess, between this law and those other ones. This was a law addressing a very specific and discrete mischief. That's a bit easier to deal with than a wide-ranging area like AI or online harm. Some of it also just comes down to political realities. Governments change, so do legislative priorities. But in fairness to lawmakers and rule makers of other sorts, there are also some real challenges in trying to write good laws for fast-changing technologies. This is a quote that I think is most plausibly attributed to Niels Bohr, but I think was made famous by Yogi Berra, the baseball coach. It might seem trite, but it's really onto something when they're talking about some of the challenges when it comes to rulemaking for emerging technologies. If you take the currently very topical example of AI regulation, an obvious problem is that there exists a wide array of highly disparate predictions about its likely limits, uses, and eventual impacts. Take a look at this quote and tell me who you think said this. AI, what will it mean? Helpful robots washing and caring for an ageing population, or pink-eyed terminators sent back from the future to cull the human race? Any guesses? Anybody remember this guy? I love this quote for various reasons. One of them is that Boris Johnson's sort of spectrum of benign to malign uses of AI starts with robots caring for the aged, which I think for a lot of people is kind of more towards the dystopian end of the spectrum. But that aside, time-travelling terminators probably aren't the top of most people's watch list when it comes to AI perils, but there are some pretty serious people expressing some pretty serious concerns. The recent open letter Richard alluded to, calling for a 6-month pause in the development of powerful AI systems, gives a sense of what these might be. Should we let machines flood our information channels with propaganda and untruth? Should we automate away all the jobs, including the fulfilling ones? Should we develop non-human minds that might eventually outnumber, outsmart, obsolete and replace us? Should we risk loss of control of our civilization? And there's some pretty serious people, both from the AI industry and the tech industry, putting their names to that. Are these risks plausible? Will AI take more jobs than it creates? Does it pose an existential threat to our civilizations? And how on earth is law supposed to respond to such dire predictions? A couple of lessons, I guess, that when I'm introducing this subject to my students and when I'm speaking to government people about it, as I did a wee bit in New Zealand, we have to start with a little bit of humility from the lawyer's perspective. Not every problem in the world can be fixed by law or by more law. If your only tool is a hammer, then every problem can look distinctly nail-like, but there are good reasons for caution when trying to resolve every social problem with a legal solution. The law is a very particular kind of tool. It's good at certain things, but there are many others available: education, social pressure, etiquette, non-legal rules of various sorts, market forces that govern particular places. A central tenet of liberal thought is that there is, or there ought to be, a realm of private life that's simply not the law's business. Now, precisely where that border should lie is contested, but I think most people would agree that there is a border. If nothing else, we'd presumably agree that there should be a de minimis threshold, whereby resources of law enforcement would be wasted on trivia. And there are instances where the presence of more laws and rules, while giving the appearance of doing something, don't actually help those at most risk. A few years before I left New Zealand, I was contacted about this guy. This is Tony Ross, better known to New Zealanders as Tauranga Tony. Mr. Ross was a freelance sperm donor. What does this have to do with AI? Bear with me. He's a freelance sperm donor who'd been offering his services via a Facebook group. His clients were women and couples who were desperate for babies, of course, but who for a variety of reasons, time, cost, didn't want to go down the official clinic route. Several of the mothers had made complaints about Mr. Ross, alleging, among other things, that he lied to them about how many other couples or how many other people he was providing his services to. He had by this time fathered at least 20 children, possibly a good many more, which in a small, close community, well, I hardly need to spell it out. At that time I had a role on New Zealand's assisted reproduction regulator, and I was contacted by the media in that capacity. I was asked if what Tony Ross was doing was against any laws, and I told them, as far as I could see, it actually probably wasn't, for reasons I could talk about if anyone was interested. The next question was, ought it to be? Is this a gap? Should we have laws to stop what he's doing? Well, that was a trickier one. On the one hand, if he really was inducing people to get pregnant with his sperm on the basis of misrepresentation, that seemed morally wrong. But was it the sort of wrong that law could fix? After all, these women had been driven out of the regulated official sector because it was too hard to access. Would more rules actually help them? Maybe, but we couldn't just assume that would be the case. By the way, when the programme was aired, Tony Ross made a complaint to our broadcasting regulator, in which I wasn't a party, but I was certainly implicated. He didn't succeed. And when the link to the programme went up on the website, this was the thing that really amused me. Sunday investigates the unregulated world of DIY sperm donation in New Zealand. We track down the country's biggest donor and speak to the women who've had his babies and who want him to stop. Picture. Interesting chats in the Jess Gavaghan household that night. Even if we think that technology has given rise to a problem that could potentially be a valid target of law, it doesn't invariably follow that new law is needed. There's a lot of law around, and it's unlikely that many new technologies that emerge won't interact with some of it at some or other time. Take ChatGPT and generative AI generally as an example. What kind of areas of law might that interact with? Well, defamation law, if it produces damaging lies about people and other people repeat it. Copyright law, we're seeing that already as being an issue. Privacy and data protection law, when it scrapes up data from other sources to inform its results. It was the presence of existing data protection and privacy law that led to the Italian privacy regulator, Garanti, banning ChatGPT for a while in Italy. They didn't need new laws for that. It was the existing laws that they relied upon. Most recently, the competition regulator in the UK is taking a look at ChatGPT using, again, existing laws. So I guess my kind of lesson here is, before we rush to scratch build a new regulatory or legal response, let's have a look at what's there already and ask if it's not working, why it's not working, and why we might think new law would work better. The accretion of so much law, I recently came across this great expression, legislative space junk. Just this idea of kind of so much bits of law floating about there in the environment that it's getting hard to get anything else through without bashing into some part of it. So much of it's likely to be relevant to, say, generative AI. It's starting to present a problem for drafters of new law. The EU's AI Act, for instance, has to navigate its way around the present GDPR, the new Digital Services Act, the AI Liability Directive, and various other bits and pieces of EU law, making sure that none of the Act's 85 articles or 9 annexes contradict any part of that is, to say the least, a bit of a challenge. My next issue is this one. That's not to say there can't be gaps in the legal or regulatory coverage. But as with the Maverick sperm donor case, we should pause before rushing to address legislative polyfiller. I get trapped in metaphors sometimes. Will the new law address the problem that it's posing? I was glad that Richard started with that clip today, because this is a subject I've become quite interested in. I'm actually giving another talk about it next week. One of my closest friends and collaborators in New Zealand is a chap called Ali Knott. He works for a company called Soul Machines, an AI company, and they're creating avatars like this. Now this lady to me is still wandering right down the middle of the uncanny valley, but they're getting very good, and it's not just that they look good, they're getting very good at mimicking human responses when you speak to them, at responding in an emotionally appropriate way to a variety of responses. Is this a worry? Daniel Dennett is in the Atlantic today. Actually, an article I just read at lunchtime, they're saying this is one of the greatest threats facing democracy and civilization. I don't know if I'd go that far, but I certainly agree with Woodrow Hartzog when he wrote in 2015 that he was talking about embodied robots, but I think AI avatars are at least as big a threat here, that they're uniquely situated to mentally manipulate people. Certainly some of them are being optimized specifically to do so, to manipulate or nudge us in terms of our buying decisions, our political decisions, disclosing data, personal information, and the like. The EU has responded to this in the AI Act with an obligation on providers of AI systems to make sure that systems like that will be disclosed to members of to natural persons. Their true identity would be disclosed. They have to tell you that it's an AI you're dealing with and not a person. Is this the right legislative response? Is this going to make a difference? Is knowing that we're interacting with an AI system going to help insulate us from the manipulative capabilities with which these sorts of systems are being optimized? I literally do not know the answer. My intuitive feeling is that, as with much of our consumer protection law, which is predicated on deceptive and misleading practices, it may not be quite engaging with what's really going on here, which is effective manipulation. But I'd love to speak to someone in psychology or whatever who perhaps has some more insight into that. I think it's a really interesting question. Okay, so let's assume that we decide that new law is needed. The law is the right vehicle, and existing law isn't doing the job. There's a couple of other things we need to think about here. Roger Brownsword, who's the kind of guru of technology law in the UK, has coined these two expressions: regulatory phase, which is about when we should regulate, and regulatory connection, about what we regulate and how. Both of these present challenges for lawmakers and regulators in this area. If we look at phase first, the question of when we ought to regulate. This has become really topical over the last month. The UK government last month published an AI white paper. It was very bullish about AI technology. It was very pro-innovation, and it takes this view. Rushed attempts to regulate AI too early would risk stifling innovation. What are we to make of that claim? Well, by definition, we shouldn't try to regulate too early, but when is too early? And as importantly, when is too late? It isn't as simple as saying that industry doesn't want this. On the very same day as the UK government white paper was released, the Future of Life Institute's open letter was also published, the thing calling for the 6-month slowdown of developing powerful AI. Why? Because the signatories to that letter think that developers have to work with policymakers to dramatically accelerate development of robust AI governance systems. And bear in mind that was signed by people like Musk and Wozniak and Mustak, so it wasn't just the usual suspects in law like me, it was industry bigwigs also saying this. The EU's approach with regard to the AI Act, one of the stated specific objectives of that Act is to ensure legal certainty to facilitate investment and innovation in AI. So even if we were only concerned about the impacts on innovation, it isn't clear that holding off with regulation is the right way to go. And of course, there are a great many areas where stifling innovation is precisely what we want to do. The areas that the EU is hiving off as unacceptable uses of AI. That's the kind of bad innovation that we don't want. What I can say as a lawyer, though, is that there are risks on both sides. Failing to regulate until something bad has happened has an obvious cost, but there are risks with going too early as well. This is the one and only tax case that I could say anything about, and I couldn't say very much about it because I don't even know what the rule of apportionment is, so please don't ask me that. But I love it because I love this underlined bit here from Justice Frankfurter. He's talking about courts and judges here, but I think it applies to lawmaking maybe more generally, that we ought to be wary of raising questions that we ought not to anticipate, and we ought not to embarrass the future by answers that can at best only maybe constitute a guess in terms of what's likely to come next. This brings me to Brownsell's notion of connection, what to regulate. Obviously, law can sometimes struggle to keep pace with technologies that disrupt our prior understanding of how things had to be. If you take the example here of driverless vehicles, it was quite fun time in New Zealand when we noticed that some of our existing road traffic law probably didn't apply, or might at least not apply, to driverless vehicles. If you look at the rule against speeding, starts with, a driver must not drive a vehicle at a speed exceeding the applicable speed limit. Well now, what if the car didn't have a driver? Would a driverless car be able to speed all it likes? Maybe. It's easy to be sympathetic for lawmakers in that situation. You know, in 2004 is not that long ago, but driverless cars weren't realistically on the horizon at that point. And honestly, this isn't the biggest problem in the world, because a very, very easy fix suggests itself before driverless cars will be allowed on the roads there. Sometimes, though, the problem can arise even when lawmakers had a particular technological target in mind. Way back in 1990, UK Parliament was concerned about the prospect of... Can anybody guess who that sheep is, by the way, before I say anything else? Dolly the sheep. That actually is a picture of Dolly the sheep. Trust me, not just a sheep. When you live in New Zealand for a long time, they take their sheep seriously. The UK Parliament decided that they weren't going to allow human cloning, so they passed, as part of the Human Fertilisation and Embryology Act, a rule against cloning. 6 years later, Dolly was born, and the government said, it's all right, this is in hand. We banned this years ago. There was no prospect of it being used to make a human, except that the people who drafted that law against cloning didn't just say cloning's banned. No. They defined very specifically what they meant by cloning, and the very particular form of cloning that they described wasn't the one that was used to create Dolly. Panic ensues. Do we have could someone go ahead and clone? The Parliament rushed to a legislative patch to make sure they couldn't, before eventually the House of Lords, as was, took a kind of elastic interpretation of that rule to say that, well, actually, we think it was probably meant to cover all kinds of cloning, really, probably. What's the lesson from that case? To draft laws with more elastic definitions so they can stretch to new and unforeseen forms of technology? Well, maybe. But this gives rise to a regulatory tension, because if law is going to serve not only as a bottom of the cliff sort of mechanism, but as an action guide, we should, after all, be able to try to comport our behaviour and to adhere to the law, not just wait to see what happens afterwards. Then it can't be so elastic that we can't predict how it's going to be used and how it's going to apply. This is a genuine regulatory tension. Here's another one. I like these bumper sticker type titles for slides. Nothing ages as quickly as yesterday's vision of the future, so said Richard Corliss. And I love this cartoon as well, from Popular Mechanics in 1950. As best I've been able to find out, it was not meant to be a joke or satirical or anything. It was the cartoonist's vision of how the housewife of 2000 would be living her life. Leaving aside the aesthetic atrocity of a completely plastic wet room with a drain in the middle for the living room, what really strikes me about this cartoon is the complete failure to consider that technology reducing the burden of housework might in some way change or even obviate the need for housewives. And certainly the notion that in 50 years' time they would still be dressed like Lucille Ball clearly hadn't occurred to them in the slightest. So when we're trying to predict enough of the future to make good laws for it, it's not just the form of technology we need to think about, it's the uses of that technology, it's the ways that technology might change our society in a variety of different ways. I love this example. This is a sign from a lecture theatre in Otago University. There was a no eating in the lecture theatre, no drinking, and no whatever the hell this is. Because no one under 30 has a clue what that's meant to even be. And when you ask them, well, you say it was actually a cell phone, and they get over the laugh again. You say, why do you think there was a rule against using cell phones in the lecture theatre? And you have to explain to them that there was a time, I know, right, there was a time when the predominant use for cell phones was to speak into them, or more plausibly, to shout into them. Fast forward to an era where these are just very small, powerful computers. Should that rule still apply? If people are using it to take notes, to look things up, to record lectures, does the rationale for that rule still make sense when cell phones have been used in a very, very different kind of way? Disconnections proving an issue, the prospect of regulatory disconnections proving an issue for the EU with regard to the AI Act as well. The approach taken in this draft legislation is there's the kind of red lines around the things that are not going to be allowed at all. And then we have a series of a kind of stratified risk hierarchy or perceived risk hierarchy. That risk hierarchy, at least in early drafts, was based around intended use of AI systems. There is a whole issue about how you define AI systems at all, but the biggest controversy, I think, has been around this risk classification hierarchy. So the unacceptable risk are the things that are banned altogether, and then you've got high-risk AI systems that are subject to a bunch of special rules if you want to introduce them into the EU jurisdiction. High risk is defined largely not by the form of the technology, but in the context, the intended use and the context in which AI systems could be used. So it's things like employment, access to services and benefits, border controls, law enforcement, a whole bunch of areas where it's fairly high stakes kind of stuff. And then relatively late in the process, the Parliament kind of thought, well, hang on a minute though, we now have these kind of general purpose AI systems that could be put to a pretty much infinite range of different uses in different contexts. It's impossible really to imagine what they might all be. So they've rapidly, well reasonably rapidly as these things go, added on a bunch of new provisions that will deal with general purpose AI systems as well as this kind of high risk list. So, almost over to you guys. This is my new law checklist. This is the kind of checklist I give my students. This would be like the introductory lecture if I was back in Otago. Here are the kind of questions we should be asking when we think about the need for or the utility of new rules for new technologies. Is this even the sort of problem that law can plausibly address? Is it, like the Maverick sperm donor case, a problem that's perhaps come about because things are a little bit over-regulated already and hard to access? If it is, what law already exists? And why isn't the existing law working? Why might we think that the new law would do a better job than the law we already have? These aren't question-begging questions. I mean, they genuinely are open to a number of different answers, but we ought to be asking them, I think. How will law fit with existing law? Remember the legislative space junk. How will it work its way between all of those? Is the new law just a regulatory placebo? Something put in place to make us feel better, but not actually be any better or be any safer? Do we have a clearly definable regulatory target? Can we actually say what it is that we're trying to regulate? And can the law be elastic enough to cover new and unexpected forms and uses of a technology without losing its function as an action guide, without becoming so loose that it doesn't tell us anything actually useful? I'd love to, as I say, I really hope this is the beginning of a conversation, not just for the next wee while in the Q&A, but over the next months and years with a lot of you. So thank you very much for now.